You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
Hi there, members of the jury, and thanks for tuning in to another episode. Today's issue that we're taking to the box is one that lands somewhere between criminal law and immigration, something that's referred to as crimmigration. Now, over the past several decades, immigration in this country has been a super hot button issue. Hundreds of thousands of people are seeking to enter this country every day, both legally and illegally. With this influx in numbers, our country has been seeing record numbers of deportations. A portion of those deportations come specifically because a non-U.S. citizen has been convicted of a certain criminal offense. In fact, the lines between criminal convictions and immigration consequences have become so blurred that the United States Supreme Court has ruled that it is within the duties of a criminal defense attorney to advise their clients about the possibility of immigration consequences as a result of their criminal case. Fortunately for us today, we have a guest who is an expert in crimmigration. He's going to be able to help us get a better understanding of what all of this means. So with that, Kevin, please introduce yourself to the members of the jury.
Thank you, Lucas. I really appreciate that. And that was quite the introduction. That's a great way of describing all of this craziness that is immigration and how it intersects with criminal law, or I guess how you think of it, how criminal law intersects with immigration law. My name is Kevin A. Gregg. I'm a partner at the law firm Kurzban, Tetzeli & Pratt. Our main office is based in Miami, and we've been at it for about 40 years now. I'm based in San Diego. I'm the San Diego office of Kurzban, Tetzeli & Pratt. Before I came to KKTP, I was a attorney advisor in the San Diego Immigration Court for 2 years through the Attorney General's Honors Program. And then after that, I went and took a federal clerkship in the Southern District of Florida, dealing with criminal issues, immigration issues, and of course, civil issues. And when I was done with my clerkship, or as it was finishing up in 2016, a certain individual who I don't agree with won the presidential election. He was talking about Muslim bans and all this terrifying stuff that really just horrified me. And I wasn't sure if I was going to go back to immigration law. I liked it a lot, but it's really hard and it takes a really emotional toll. And it's not as lucrative as other areas of law, but he's talking about Muslim bans and really making immigrants the enemy. That I sent an email to an individual who I knew had been suing the U.S. government for 40 years, Ira Kurzban, who happened to be based in Miami, and said, "Do you need some help?" And he did. And I went to go work for him after my federal clerkship, and the rest is history. So thank you, Donald Trump. Because I've got a great career. I've been very lucky in my career with some of the great mentors and great experiences I've had so far, and I want to continue to keep doing that. During the pandemic, actually at the suggestion of my fiance, I started a podcast called Immigration Review, where every week on the podcast, I am analyzing and summarizing and offering practice pointers for every published immigration decision out of all the circuit courts of appeals and the Board of Immigration Appeals, which is kind of like the Supreme Court of immigration judges. And of course, the Supreme Court when they hit up immigration, which happens once or twice a year. And so that is 13 tribunals, because the DC Circuit does not take immigration issues, at least from the immigration courts. And it's been a wild ride. It's been a lot of work, but it's receiving a lot of good feedback, and I think it's helping the bar. So I've had a lot of fun with it, and I'm going to keep doing it. And I really appreciate you having me on the show to talk about that and to talk about a lot of the issues we speak about on the podcast, which is crimmigration, because every week there's at least one, maybe more, crimmigration type cases.
Well, Kevin, we really appreciate you taking the time to come on to the show and help sharing your expertise. I think everyone would agree that whether there's new news coming out of a courtroom or a news outlet, the immigration is just kind of everywhere in this country. And even on that kind of surface level, though, I don't think a lot of people realize the depth that immigration goes. So many people don't realize that there's different kind of statuses that people can be eligible for or have, and then what consequences they face. We hear a lot of buzzwords in the media like DACA and legal permanent residence, but no, or pathway to citizenship. But not many people really take the time to get to know the ins and outs and to see the effects that ultimately happen with the system that we currently have and the way that it changes, as we've seen, obviously, from 2016 to some of the current issues that are arising now. So, again, we really appreciate you taking the time to come on. One of the first things that I want to pick your brain about, especially as a criminal defense attorney, is that when I first interact with one of my clients, at some point in time, early in that interaction, what their citizenship status is becomes extremely important to the conversation. And it can be a very invasive question that people are often reluctant to answer or sometimes not be truthful about because they understand the possible implications that can then arise from, divulging their actual status. And so one of the ways that I've come to try to work around that question is to simply always ask a client, where are they born? Because once they provide me with a city, I'm usually able to decipher whether or not a U.S. citizen. And the reason that I need to know whether or not they're a U.S. citizen is because I have to advise them that as a result of this criminal case, they may be denied admissions, naturalization, and deportation into the United States. And so can you go ahead and explain to our listeners what's the difference between those three categorizations of consequences when it relates to immigration?
And that was, removability and admissibility and
naturalization.
So I am going to answer that question. I'm not going to do what lawyers do and answer the question they want to ask instead. I will get back to it, but I want to hit on a couple things that you said before I answer that question. You mentioned DACA and you mentioned pathways to citizenship, and I want to be very clear about both of those. DACA, it affects about 1 million people, all individuals who came here when they were under the age of 16 and many years ago at that. They are, some of these DACA recipients, at this point, they're our age, most of them. And a lot of them don't know any other country. And some of them thought that they were U.S. citizens until they found themselves in a detention facility. Can you imagine? That could be you or me. There was going to be a legislative fix that would have given the Dreamers status, but the Freedom Caucus blew it up under Obama, even though there was bipartisan support, including from the Gang of Eight, and a majority of Republicans. But a minority of the minority, because the Republicans had the minority at the time, they might have the majority. Either way, a minority of the Republican Party prevented the Dreamers from getting a path to lawful status in this country. And I think it's important to remember that. The only reason that those individuals have not lost their DACA status to the extent that it was granted to them by executive order is because Justice Roberts decided he wasn't going to do it. The DACA decision last term was 5-4. Justice Roberts based it on the Administrative Procedures Act, which is a very, very shaky ground to do it because, at best, it means that had Trump won, he could have and would have done it again. He would have just done it right in a way that complied with the law. So elections matter. Justice Roberts deciding, just like he decided in the Commerce case, said, I'm not going to go this far. I'm not going to let the country go this far. We should all be thankful that he decided to do that. And so immigration gets so complicated, and there are multiple cases at the Supreme Court every term on the issue. When people talk about a path to citizenship, and President Biden has already put forth his massive immigration bill, and we'll see what happens this go around, we're talking about green cards. We're not talking about all these people getting citizenship We're not even necessarily talking about them having a path that's the same as the path that's currently in play, which is very onerous, by the way, already. We're talking about green cards, some sort of lawful status that may, if they meet all these other qualifications, in many years lead to citizenship. So that is what generically that term means, and what's going on with DACA as well. But DACA is always going to be temporary until Congress acts, and it's always going to be at the whims of a 5-4 majority, which is now 6-3, as you know, on the Supreme Court, and the president. So hopefully there is a fix under President Biden. Some sort of agreement can be reached.
Yeah, I know we definitely hope so. I think you really highlighted a key distinction that I think is often overlooked, and that is essentially there's a very distinct difference between being given permission to be in the country or live in the country and being given the privilege and immunities of actual citizenship.
Absolutely correct.
I think that people think that if you're here legally, that just means one thing, that means you are a citizen and that you get all these things. They're not aware of what the actual path to citizenship entails, that encompasses a period of permission to be able to be in the country, but without those protections. And so, highlighting it the way you just did to me really made that distinction clear. So I really appreciate that answer. That kind of leads me into the follow-up, I guess, as to one of the things that we also have to clarify is not only is our client potentially a citizen or a non-citizen, but just like we were talking about, that what their status is. Because obviously, if you are a non-U.S. citizen, you automatically, or you are not here legally at all, you automatically face deportation just as a result of your status, let alone any kind of criminal conviction. But for those who are not here legally and are not citizens, why does their different kind of status, or how can their different kinds of status be affected by these certain criminal offenses?
Absolutely. And so that does get to your first question. The difference between inadmissibility, removability, and naturalization. I'll start with naturalization first. Naturalization is literally how one becomes a U.S. citizen if they're a lawful permanent resident, aka a green card holder. If you're a green card holder and you want to become a U.S. citizen, and you qualify, you naturalize by filing an application, and if you meet all the qualifications, you can naturalize. Certain convictions will prevent you from naturalizing. Not to get into all of the elements, but first of all, you need to show that you've been a person of good moral character during the either 3 or 5 years preceding your application, depending on the basis of your naturalization. You need to show that you're a person of good moral character, and any conviction could prevent that. Heck, a DUI arrest without conviction could prevent a good moral character finding. And so with such cases, maybe you wait 5 years and you apply then. But other convictions, like a conviction deemed an aggravated felony, and I'll get into that in a second, that'll bar you from naturalizing forever. And not only that, it'll make you removable. I'll get to that in a second. And so the stakes are huge there when you're talking about, for example, an aggravated felony conviction. If you're convicted of a fraud type crime, it might be the case that if you're convicted of a crime let me step back and it'll get to removability, and then I'll get back to what I'm going to say. Removability is when the U.S. government alleges that you need to be deported from the United States, an individual. That is regardless of the status an individual has. The law changed in 1997, and now we call everything removability. So regardless of how you came here, whether you hopped the border or whether you currently have a green card, if the U.S. government says you got to go, they serve you with what we call a notice to appear before an immigration judge, and the government needs to prove its case. Now, just exactly what the government needs to prove depends on the facts of a specific case. Sometimes they simply need to prove that you were born abroad and you have no right to be here. Other times they need to make a showing based on the criminal conviction. But either way, that's what removability is. And So then going back to naturalization, if you have someone who's applying to naturalize, that person is necessarily a green card holder. They can be here for an indefinite period of time unless they do something that warrants their removal. If they have an aggravated felony conviction, not only is that going to bar them from naturalizing, but then the government's going to turn around, put them in immigration court proceedings, and try and take their green card away and deport them to the country that they're from. So it's going to be a double whammy for them. Not only that, and we saw this in an 11th Circuit case just today. Actually, it was unpublished, so I won't be talking about it on the podcast, but it did come across my window. When you apply to naturalize, or to get a green card for that matter, you swear that you have never committed an offense for which you haven't been arrested. Now, can you imagine that? I don't think anyone can. I mean, right? I mean, you probably committed a crime today that you weren't arrested for. Who knows? I mean, did you download a song in 2001 on Napster? It's a very broad question. It doesn't come up in many instances, but sometimes it does. And if you have a client that pleads to a conviction based on conduct that predated their green card, the government can turn around and say, you lied in your green card application, or you lied in your naturalization application when you said you hadn't committed an offense for which you hadn't been convicted. And because you lied, we can take away your green card and deport you. So it's not just convictions. It gets very hairy. And attorneys who take only naturalization cases because they think it's straightforward are really rolling the dice, because, as you know, as an attorney, rarely are things straightforward. And if you don't dig into your client's past, you're going to get dinged. You're going to be in a rough situation if the other side knows about it.
And again, you highlighted, I think, such a crucial part with us. It goes so much beyond just what the end conviction is. One of the things that we're often trained on is what's called the record of conviction, because one of the things that is attached to the conviction is what's called the factual basis. And what that factual basis says can be very detrimental to people as it relates to their immigration consequences, even if the conviction that they're receiving is relatively immigration safe. So there's so many different layers and components that I think go into the review of someone's immigration status and their consequences, and that, crimmigration is so vital in ensuring, I guess, the best ultimate outcomes, not only in the criminal courts, but then subsequently in the immigration courts.
That's absolutely correct. And it leads me actually to the last thing you asked about, and that is inadmissibility. What is that? It all goes back to the change in 1997 that happened. Newt Gingrich Congress forced a very harsh immigration bill on Bill Clinton that really solidified the infusion of criminal law into immigration, and has really created a lot of these problems that immigration attorneys and non-citizens have to deal with today. It's the IRA law that went into effect in 97. And that's when removability and inadmissibility came about. So recall, removability is when the government's trying to say this person can no longer be in the country. Here's why. It could be as simple as saying that they entered without inspection and authorization, or it could be as complicated as saying this conviction means that we have to take their green card away. Inadmissibility, though, is supposed to be when someone is outside the United States trying to come in. So you're always dealing necessarily with individuals who are in the United States and what is going to be the consequences. But a whole other part of immigration is individuals who are outside the United States trying to get a visa to come in, be that based on their marriage, an employment, so many ways, an investment. There are many ways to get a visa, even a tourist visa. That is people trying to go into the consulates that we have abroad and trying to come in. And the same immigration analysis applies. And those people can't come in, absent a waiver, if they are inadmissible. But inadmissibility also comes into play, and this is where it gets a bit complicated, in the same immigration court where the government is trying to remove someone. And here's how. If an individual is removable, again, let's say that they came in unlawfully or their green card is going to be taken away, they can stay in the United States if an immigration judge grants them relief from removal. Forms of relief include asylum, which you hear about all the time, cancellation of removal, either for someone who's had a green card before, they'll get a second chance, or non-LPR cancellation of removal for individuals who had no right to be here legally, but they've been here for at least 10 years, they actually can get a green card if they show exceptional and extremely unusual hardship to their U.S. citizen, spouse, parent, or child. It's a very, very high bar, but it's available. So there are all these grounds of relief. But for many grounds of relief, if you are deemed inadmissible, you don't qualify. And so that's how inadmissibility comes into play in immigration court. And this comes back to what you were saying about the plea colloquy, because there are certain forms of inadmissibility that don't even require a conviction. The concept of, say, a crime involving moral turpitude, which I understand has a state law corollary, but in immigration, it means a certain thing. And in the 1950s and in the 1920s, when this term came to be, it meant homosexuality. How this term is still constitutional is beyond me. But the Supreme Court found it was in 52, and it hasn't taken up the issue again. There are certain Ninth Circuit judges who, it seems like every month, want the Supreme Court to take it up again. Judge Berzon is one of them. She just issued a decision this week reaffirming her belief in that unconstitutionality, but it still exists and it's still there. And to be deemed inadmissible for a CIMT, or to be deemed inadmissible for having violated a law relating to a controlled substance, even if it's legal in your state, you just have to admit to the essential elements of the crime. And there's a whole framework on that. But if you admit to the facts in a plea colloquy in criminal court, let's say you admit that you did cocaine in your plea colloquy after knowing what the statute of conviction is, and you plead down to, that could be the basis of an inadmissibility finding for having violated a law relating to a controlled substance. And there's no waiver. I mean, we treat the drugs harsher than almost anything, harsher than a lot of things that you and I may believe warrant a harsher punishment in this country. If you have a conviction for having ingested cocaine, there's very little I can do for you, despite all my creative legal arguments.
Yeah, and the crazy, and I think that hits the nail on the head on why there's so much intersection between immigration law and criminal law, because one, the substance abuse problem and an epidemic in this country has, shifted from one drug to another from the last several decades. And, the war on drugs has not been the solution. What it has done is, led to mass incarceration, led to mass deportations. And, personally, I don't believe that is the solution to either of the issues or the drug issue at large anyway. So, that's totally, and you hit nail on the head with when you talk about them being charged with, a misdemeanor controlled substance. We might be able to negotiate a lesser included offense, but it relates back to that factual basis. What are they actually saying that they did in connection to what was written down in their police report? Because all of those things are ultimately go under review when it goes before the immigration courts, even though with the criminal court, we can cut certain parts out or based on certain facts that we see, make certain deals. It doesn't sound like those then deals ultimately make their way to the immigration. So it's really, really crucial that all aspects of your conviction record are in line with the best possible immigration consequences.
Oh, what makes its way to the immigration court is that final conviction and certain documents, the plea colloquy, the judgment, and the indictment, all of that. But in immigration, when you're talking about most criminal conviction analyses, we use what's called the categorical approach. that's used also in federal court in the sentence enhancement context, the ACCA, when you have one conviction and then you're going to enhance it because you have other convictions, like, say, a violent felony. It's in federal court. We use the same thing in immigration court. The most recent Supreme Court case on the subject is the Mathis decision. Before that, the Discamps decision about this whole blinders, and it really does benefit the non-citizen. Even if, for example, you have been convicted of ingesting cocaine, if the statute you are convicted under also criminalizes ingesting, 5 grams of marijuana, you might not be removable, even though you actually ingested cocaine. It's a whole analysis of whether or not that criminal statute is divisible and whether or not the immigration judge is allowed to look beyond the statute and try and get into what the non-citizen actually did. It's a very complicated analysis, and I'm not going to get into it here because I think it'll just bore everybody to tears, but it's what we do every day in Crimmigration. And I bring it up because one of the interesting facets of it, and one of the areas of law that's constantly shifting and that the Supreme Court will probably address in the coming years, is called the realistic probability test. And the way it's supposed to work is if you have a statute, let's go back to our cocaine hypothetical. If you have a statute that appears on its face to cover removable conduct, the non-citizen can still avoid removability if they can show that there's a realistic probability that the state applies that statute in a manner that doesn't make them removable. And let me give you an example of how that could happen. And it gets really wonky and it's crazy, but this is kind of how you could help. And we'll stay with cocaine. And I don't even know what these things are, but maybe you've heard of the concept of cocaine isomers. Cocaine isomers are kind of like the chemistry of cocaine. I don't know much about it. The federal government does not criminalize possessing cocaine isomers, but most states do. That means that the state is criminalizing something that the federal government is not. And that means that the state offense might not make them removable. It's a stupid, wonky, academic inquiry, but it could have real life consequences. Some courts might say, well, I understand that you're saying California criminalizes possessing cocaine isomers and the federal government doesn't, so you're not removable. But California would never realistically criminalize possessing cocaine isomers. You need to show us a case in which California has actually prosecuted possessing cocaine isomers. If you can't, you're removable. Or if you can't, you're ineligible for relief from removal. And this is where public defenders and immigration practitioners need to come together. There is, not that I know of, no one's really talking to one another to create a database of these convictions to help immigration practitioners satisfy the realistic probability test. You need a case where someone is convicted of child endangerment, where they have simply left their 5-year-old sitting in front of the television for 2 hours. Here's the case. California prosecuted my client with that in 2014. That might save an immigration non-citizen if you can point to that case. You need a case where California has prosecuted possessing cocaine isomers. I did that last week. There is no database. No one's really talking. There are Padilla attorneys in Texas, I know, and I think Los Angeles, and kind of in more of not Texas, obviously, but the more progressive states where you have these criminal defense attorneys and immigration attorneys working together and with that mindset. But, if there's nothing else from this interview, it's that we need to start talking more, because us immigration practitioners really need to know what's out there, what these states are really prosecuting, because that's how the realistic probability test is sometimes being applied. I know that got pretty high level, but I think it just says that it just shows that we need to talk a bit.
No, I mean, I agree. I mean, the government and prosecutors and the law are all coming together to, get these convictions and get these removals. So it only makes sense that the defense attorneys align and help, serve justice and put up, defenses and where they need to go and make sure that, everyone is doing their job lawfully and satisfying the elements in which they need to in order to get the consequences that they're ultimately seeking. So again, I really appreciate your experience and expertise in the Crimmigration and giving us the background into, those questions. One of the things I do want to get into while we have you is, hopefully your experience. I know while we were kind of talking before we started recording, you had mentioned that in your experience, you had a couple cases that you thought were super interesting and love to share. Here at Members of the Jury, we're all about kind of cases and true crime facts and getting just results. So, if you have one or two cases that you're happy to share with us, I know our audience would love to hear them.
Yeah, I appreciate that. And I will do it such that we don't divulge client identities and that kind of stuff. And so if I'm being a bit vague, that is the reason why. A first case that comes to mind is an individual who was convicted of conspiracy to convert trade secrets. It's a federal offense. It's a pretty vague, weird crime. Conspiracy to convert trade secrets. But what he was doing could be classified as espionage. And the government did classify it as espionage. And there is an espionage ground of removability. And it never comes up, right? I mean, who gets a spy case? It just doesn't happen. There's like 3 published decisions. They don't really say what has to happen for someone to be removable. My client had a green card. For someone to be removable for the espionage ground of inadmissibility, removability. At the same time, the government charged my client as an aggravated felony. And there's approximately 30 different types of aggravated felonies, depending on how you classify them. And an aggravated felony is an immigration concept. It doesn't even necessarily mean it's a felony, as that concept is understood in a state like California. But the definition is under immigration law, and a theft offense in which an individual is sentenced to at least 1 year or more, or I think it escapes me, it's either 1 year or more or over 1 year of imprisonment. A theft offense, as defined under federal law, will be an aggravated felony. They charged him with both. And through a lot of argument, we beat the theft aggravated felony rap because of this categorical approach. The conspiracy statute criminalized conduct that wasn't a theft. Under federal law, if you steal something by fraudulently inducing consent, saying, give me your purse, I'll hold on to it for a minute and give it back to you, and then you go steal it, fraudulently induced consent. That's not theft under federal law. That's fraud. But the aggravated felony theft offense only criminalizes theft. And because you couldn't go and see what he was actually convicted under because of the categorical approach and a whole nother podcast between you and me, he beat the aggravated felony rap. But they ended up finding that he was removable for the espionage ground. But to be honest with you, I really think we had the better argument. I wanted to take it up to the circuit court, but for a variety of reasons, we couldn't. The client didn't want to. That kind of stuff. But I mean, it could have made some great law. Because this conviction that he had, I mean, you could take somebody's drawing and, just use it as your own. To me, espionage, the history of espionage means that you have to be doing it on behalf of a foreign power. You have to be doing it with that in mind. And putting aside what the client did, the focus is on the statute. And the statute clearly has no requirement that it be for a foreign power. And this is how the crimmigration analysis works. You're looking at the element of the crime and matching it up to the elements of the federal offense. So that was an interesting case. I wish I could get into more details. It would be even more interesting. Another one with a bit of a better outcome was...
Kevin, let me interrupt you real quick before you get in started. And I think I should have asked this prior to the first story, is if you could... go ahead and set a little bit of the scene as for how these kind of cases are taking place. A lot of our audience are used to hearing the details of a criminal jury trial where, they know there's a prosecutor and a judge, a defense attorney, and this all of this stuff is happening before a jury. Go ahead and paint the picture in the scene of kind of how are these immigration hearings or trials, how are they playing out?
That's a great question. I thank you for asking it. And I used to work for these judges for 2 years, and I have great respect for them, having worked for them. But paint the scene. Picture the smallest courtroom you've ever seen. Picture, in some cases, 2 rows, enough space for maybe 15 people to sit in the courtroom, no windows, prosecutor and the defense sitting 3 feet away from each other. And if the individual is detained in what we call immigration detention, he's usually going to be appearing in immigration court through a video. So he's not in court. We call it immigration detention. These are private prisons. I think it's 100% private prison owned in this country at this point. For-profit entities that are some of the biggest lobbyists of Congress. The U.S. government pays approximately $120 a day to detain non-citizens. That was a Second Circuit case recently. And per Congress's statute, a certain amount of individuals must be detained in our country at any given moment. So if me as an immigration attorney get my client out on bond, might result in DHS going and picking someone else up because the law, as lobbied by private prisons, requires it. That's a little aside there. Whatever. You can think what you want if deterrence is a legitimate reason to detain human beings, but it certainly comes at a high cost. There is no question about that. Anyway, in the case of a detained, you either have a detained or a non-detained non-citizen. Under the Biden administration, a lot of the individuals are now non-detained because they're not wasting money on individuals who aren't a threat to their communities and who aren't a flight risk. Either way, you have the non-citizen. That individual is not necessarily represented by an attorney. In fact, I think only 25% are. You don't have a right to an attorney. You have a right to an attorney in immigration court, but one is not provided to you by the federal government unless you are mentally incompetent, which is a very high bar, or in some cases, unless you're a child. There are some states, some progressive states that are now making their own essentially their own public defenders for immigration, but those are few and far between, and that's a state initiative. So you have 75%, a lot of the time not English-speaking individuals representing themselves in immigration court, and I have only hit the tip of the iceberg on how complicated immigration can get. They are called respondents. The government, which is essentially the prosecutor, is represented by the Department of Homeland Security in the sub-agency ICE. ICE gets a bad rap for a lot of reasons. You could agree or disagree, but usually that's ICE enforcement. These are ICE attorneys. I have a lot of friends who are ICE attorneys. I've never met a, bad individual. I respect them greatly. Kind of probably how you feel about prosecutors who you go up against in the criminal defense bar. And then it's all presided over by an immigration judge. But the name judge is kind of a misnomer because technically they are employees of the Department of Justice. So you have a Department of Justice attorney presiding over litigation with a non-citizen and a Department of Homeland Security prosecutor. And the judges are weird constitutionally because they are some of the only Article 2 judges, Article 2 being the president. Bankruptcy judges, drug judges, they're Article 1 judges. They fall under Congress, and that has been deemed constitutional. But immigration judges fall under, technically, the authority of the Attorney General. The Attorney General has authority to issue published decisions like he's the Supreme Court himself. He or she is the Supreme Court himself. And under the Trump administration, the Attorney General's issued about 15 published decisions in 3.5 years, and each one of them was a grenade. I'm pretty sure that the Obama, W. Bush, and Clinton attorneys general combined, and that's 12 years, probably issued less than 15, and a lot of them were kind of meaningless. So the Trump administration knew what it was doing. The Attorney General can't really tell the immigration judges what to do, but what he can and what they did do under the last administration is create these bureaucratic requirements that can make the life of an immigration judge miserable and incentivize denials and adverse rulings towards a non-citizen. For example, the Jeff Sessions administration required that immigration judges complete 700 cases a year. It's a lot of cases. There was at one point they were doing something like 80 initial calendar hearings a day. I mean, it just burns judges out, and it necessarily prevents you from giving it a lot of thought. So that's the scene. Set the scene. But if you hire an attorney like us, and not to give us, not to promote us, but we're going to make the judge think and wrestle with the law, because that's our job, and you can't ignore it. And 95% of all judges, you become a judge because you want to deal with the law. You want to be intellectual. You want to do the right thing. I don't care who appointed you. And so that's how we practice in immigration law. So that's the scene. And under the Trump administration, sometimes, especially with detained settings, I mean, sometimes you got one hearing in the case on a Monday, and then the next hearing in that case the Monday afterwards. I mean, the hearings could be set that quickly. So when you're in detained removal proceedings, it really can be very quick, and the stakes are very high.
That's so fascinating and interesting. And I mean, I think it definitely...
In every case, I'm saying every case is a bench trial.
Yeah.
There is no...
And that's exactly what I was about to say, that has to be such an interesting component or, takeaway from the immigration courts, is that, you have an inability to really pull on any kind of emotional strings. Obviously these judges are trained in the law how to set emotion aside, and there's obviously a component, I think, in the law, in the Constitution, that even though it's not to be considered, and there's case law and jury instructions that say you aren't supposed to consider emotion, the fact that the Constitution allows, when you're facing your liberty, to be in front of a jury of your peers, there's no getting around that. There's always going to be a bottom line of emotion in play to get a sense of kind of how the community feels about the situation that's being presented. And to take that away when, immigration law is just someone risk someone's liberty just as much as, a potential criminal case does. Because as you indicated, oftentimes, these individuals are facing deportation and removal to countries that they've never been to, that are predominant in languages that they don't speak, and that they don't even have any other family or relatives living in. And so that's such a crazy dynamic. And, obviously people who are able to hire you to represent you, are fortunate to have that representation to get that best fighting chance of, overcoming that removal proceeding.
There are many judges, a lot in the Ninth, but in all circuits, there's some quote like, immigration court is a death penalty case with traffic court procedures, which that is a bit hyperbole, but it's not so far off. And then there's also law that says that non-citizens are, usually with your clients, right? We all know what due process is. When we're talking about U.S. citizens, we have an idea, all the stuff you learn in law school. But the line of cases with non-citizens, and the Supreme Court dealt with an issue like this last term with the Haxhigeaszy decision, non-citizens are only due the due process that Congress says they're due. That is essentially the law. Now, Congress has said that they get a lot of rights depending on their immigration status, but we're not even starting at the same point as you do in criminal court. So it's quite the thing. And I don't want to be negative, and I do love being an immigration attorney, but I think it's important to know the reality. And so I want to get to that last one because it had a good result.
We love good results on this show, so please share.
That's right. No, the individual had been wrongfully convicted of a rape and spent decades behind bars. And one of those great innocence projects eventually got a federal judge to vacate that conviction. But the non-citizen, but he didn't have status in this country. Now, he was from a country that, had he not been in prison for all those decades, there had been many immigration programs that probably would have gotten him a green card. But of course, he couldn't get those because he was in prison during all those years. So that person was removable from the United States. And not only that, he had a drug conviction before, the rape conviction that the government was saying prevented him from all relief. Now, it was our position that he was going to be in serious risk of harm, that he warranted asylum and protection based on a lot of factors if he was removed. But the government was taking the position that his conviction from the 1980s, or I think that it was a drug trafficking type aggravated felony, he couldn't get that relief. The immigration judge agreed, and it went up to the Board of Immigration Appeals, but we got it remanded because of this whole crimmigration analysis. The drug trafficking provision the Florida statute that he is convicted under, in order to be an aggravated felony and thereby preclude relief, it has to necessarily require a trafficking element. And trafficking, to dumb it down, requires remuneration. And the Florida statute allows for mere delivery of drugs for no pay. The 11th Circuit had recently decided that statute that he was convicted under didn't necessarily constitute a drug trafficking crime. And and it's a lot more complicated than that, but based on all that crimmigration analysis, we got the appellate body to send it back to the immigration judge. And that individual is now living in this country with immigration status. And to tell him that he was getting out of prison, because he went from state custody, got his conviction vacated, and ICE detained him in immigration prison. The guy has no conviction after 30 years in prison, and they're going to still detain him in ICE custody. After 35 years, 33 years, to tell him you're getting out and you get to stay, and to see him at his party with his family and friends afterward, it's nothing like it. I'll remember it until I die.
That was a fantastic story and such a just result. That's why I think that both of us do what we do and ultimately strive to hear. So, I mean, that's a fantastic story.
Yeah, no, it's a good one. It's always interesting. And I asked my, the founding partner of my firm, my Recurs band, like, when does it go away? When do you stop wanting to vomit if something doesn't go your way? Or, that initial decision that you have to appeal, when does it stop? And he said, Kevin, it never goes away. And if it goes away, I'm going to be worried. And I'm sure he's right, but it's a rough way to live, but also the glory, the great human connection, actual meaningful work that's not just about money for big corporations. It's kind of the price you pay. Same as you.
Exactly. I mean, changing lives, I think, is what it's all about, or preserving lives is what it's all about. Kevin, again, I just want to take the time to say thank you for you taking the time to come on and speak before the members of the jury. I want to highlight again to our audience that Kevin hosts a weekly podcast called Immigration Review, where he discusses the latest United States Supreme Court's opinions, Board of Immigration Appeals, and all Circuit Court of Appeals. I'll drop a link to his show specifically in our show notes. So if you are super interested in this kind of stuff and you want to learn more, you should be sure to check out his podcast. Kevin, I am going to subject you to the question that we end our every show with here. It sounds like that last case was a great segue to this question. But here at Members of the Juries, we always want to know from our guest, what is the importance of taking it to the box mean to you?
I'll do it in the immigration context and why immigration is something that is so important to this country. Why it matters, all of these legal games I'm playing, and why it matters that we have due process in immigration court. I think a country's soul is in large part based on how, as the trope goes, it treats its lowest individuals, how it treats its prisoners, and how it treats its immigrants. Our national identity is that of a country of open arms that welcomes immigrants. My ancestors 100 years ago came here, and they couldn't come here today because they were poor from Eastern Europe and they didn't have visas. Most of the people in this country could not come to this country today, and certainly under the rules put into place by Donald Trump and Stephen Miller. could not come here. And we would be without all of the contributions to society that all of those individuals and their children, grandchildren, great-grandchildren have contributed. It is the soul of this country, immigration is. And not only that, I mean, if we get away from that, I think we're doing a disservice to this country. But not only that, I think history shows that if you make any group, be that group African Americans, Native Americans, Jews, if you make them the enemy, the outsider, that can be used by would-be dictators to take away democracy and to do some terrible things to society writ large. And there is a movement in this country to make immigrants that outsider, that fifth column that unifies people to put their faith in a dictator. And so regardless of what you think about immigration, be careful who you marginalize, because that Frisbee might come back and hit you in the face. That is my taking it to the box on immigration on a macro scale. On a micro scale, take it to the box. I'm going to make my best damn legal argument, and I'm going to get my client to stay in this country and get to keep his or her green card.
That's right. That's right. Well, Kevin, we wish you the best of luck in all those future hearings. You know, what you're doing is so important. This country was founded on immigration. Immigration is important to the continuation of this country. Again, thank you so much for coming onto the show and being a part of the members of the jury family.
It's my pleasure. I really appreciate being on here. I think you're doing a great thing. I love to meet a fellow podcaster and to talk with a fellow podcaster. It's a labor of love, as you know. Yes, please, to your listeners, check out Immigration Review Podcast if you're interested in immigration. Send me an email at kgregg, Kgregg, at kktplaw.com for any immigration questions. We do criminal conviction analyses. If you're not sure what the consequences of your client's plea or proposed plea is going to be, please email me and maybe we can work something out and we can help. So thank you again, Lucas. It's been a real pleasure, and good luck to you with everything you're doing and everything in your career.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.